Good morning, everyone.
Good morning.
Mary Ann, who are we starting with, please?
Well, the only one that looks like that may be a match is Mr. Wheelock is here for Christina Kroneman. Is that correct, Mr. Wheelock?
That is correct.
Okay.
And Mr. Davis is here. This is 211053SC, Robert Davis versus Christina Kroneman. Appearances, please.
Good morning, Your Honor. Joshua Wheelock on behalf of Ms. Kroneman, who is appearing with us via Zoom. She is the defendant in this case.
And Mr. Davis, state your name for the record, please.
Robert Davis.
Thank you. Today is the day and time set for hearing on the defendant's motion to set aside the default judgment that was entered by the court back on June 1st, 2021. Mr. Davis, did you receive a copy of the motion?
Yes, ma'am.
Did you file a written response to the motion?
Nope.
Mr. Wheelock, would you proceed with your motion, please?
Yes, Your Honor. Your Honor, to my understanding, the parties have met previously in court, and my client had requested a new court date to be put in front of a judge. And to my understanding, a new court date was to be set, and she would be receiving notice of that court date. Unfortunately, it appears that that court date did happen, but no notice was ever sent to my client, or at least my client never received notice of that particular hearing, and then default was entered at that time, as well with a default judgment, Your Honor. Your Honor, I think there are some significant legal defenses that my client does have, and by entering a default judgment against my client, I think she would suffer serious harm, Your Honor. Financial harm.
Mr. Wheelock, does Ms. Kroneman still reside at the Wyoming Drive address that appears on your motion?
I believe so, Your Honor. Ms. Kroneman is here. She can attest to her current address.
Ma'am, is that your address?
Yes, ma'am.
39092? That's the
Yes.
address that appears on a notice that the clerks mailed out on May 11, 2021. Mr. Wheelock, was there anything else you'd like to say this morning?
Yes, Your Honor. The allegations within Mr. Davis's small claim arise out of an auto accident, which I believe the no fault act would take precedent as far as the legal issues go, and Mr. Davis's damages are capped under the mini tort statute, Your Honor, which again is part of what we're dealing with here, as default judgment was entered far in excess of the mini tort cap.
Anything else, sir?
No, Your Honor.
Mr. Davis, your response?
Your Honor, I just didn't understand how she didn't receive the summons, and like I don't really know about the mini tort and all that stuff. Like I kind of went through it, but like I'm not no lawyer. I just was trying to, get this settled and get compensated for my car that got totaled.
Anything else, Mr. Davis?
No, ma'am.
The court has had the opportunity to review the defendant's motion to set aside, and the motion will be granted. The judgment that entered on June 1st, 2021 is hereby set aside. There was also a demand for removal from small claims to the general civil docket. That demand is being signed as well. The matter is being removed. is being removed from the small claims docket and placed on the court's general civil docket. The defendant has 14 days from the day's date to submit an answer. Mr. Whitlock did attach the defendant's answer to the or filed at the same time as the motion to set aside the default judgment. The court will be scheduling a pretrial in this matter. Mr. Davis, did you receive a copy of the defendant's answer with the motion?
Yes.
Again, this matter will be set for pretrial. I believe the date we're using is September 14th. I'm not sure of what time that will be, but please monitor your mailboxes for a September 14th pretrial date. Anything else this morning, Mr. Davis?
No, ma'am.
Anything else, Mr. Whitlock?
Just for procedural purpose, the answer that I did file, that will be sufficient for filing, or do you want me to file another answer?
That will be sufficient for filing, but Mr. Whitlock, you did not include an order with your motion. I'll make a note for the civil department to prepare a motion, prepare an order. We are all set. See you back here on September 14th.
Thank you, Judge.
Okay, thank you.
Thank you, Judge.
Judge, your very first one is ready. Beaumont Health v. Child.
Thank you, ma'am.
Welcome.
This is 211177 GC, Beaumont Health versus Angela Childs.
Yes, Your Honor. This is Hal Burke, attorney, P69068, attorney for Beaumont Health.
I don't know where she went. I'm sorry.
That's okay. I don't see her on our participant list.
We did reach a resolution in a breakout room you allowed us to be in, Your Honor.
I'm sorry, you reached a resolution in the breakout room this morning?
Yes, ma'am.
I think this is her, Judge.
Okay. Ms. Childs,
Yes, good morning.
state your full name for me, please.
Angela Childs.
Thank you. Mr. Burke just indicated that the parties have reached a resolution of this matter. Is that true?
Yes,
Mr. Burke, what is that resolution, please?
Your Honor, today Ms. Childs will consent to a judgment for the amount prayed for, which is with court costs $2,628.01. And she will agreed to pay $50 a month beginning September 10th through the 10th of each month. Obviously, I'm going to reduce that to writing and get it to her for her to sign, and then you to review, of course. Your Honor.
Ms. Childs, is that accurate?
how much? I don't have the amount here, but yes, I agreed to pay $50. I need to know the amount though. I don't have the amount.
Ms. Childs, $2,628.01 payable at $50 per month beginning September 10th, 2021, and $50 on the 10th of each month thereafter.
Okay, yes.
Mr. Burke, how long do you think it'll take you to get that proposed consent judgment to Ms. Childs?
Your Honor, Ms. Childs mentioned to me that she does not have email, but we will prepare this today and mail it to her. I did verify her address. Would you allow, because of the email issue, maybe 1 month to get it back to you? Or 20 days or so?
28 days, would that be sufficient?
Yes, Your Honor.
Okay. So Ms. Childs, you please be on the lookout for the consent judgment from Mr. Burke's office. Sign it, send it back to him. He'll sign it, file it with the court. The court will enter it, and that will be how the matter will be resolved, okay?
All right, thank you.
Anything else, Mr. Burke?
No, thank you, Your Honor.
Anything else, Ms. Childs?
No, that's it. Thank you.
Thank you. You both have a wonderful day.
Have a great day.
Thank you. Mr. Higbee, have you been in contact with Mr. Hill?
Your Honor, good morning. I emailed with him yesterday about today's hearing. I have not been in contact with him this morning. No, Your Honor.
Okay, thank you, sir. Mary Ann?
Yes, there are no other matches right now.
There's no other matches and we don't do anything until 15 past the scheduled start time. So
Your Honor?
I see Ms.
I am here on the LVNV funding matter, and I see a Renee Simpson in the participant list. So I think we do have a match, at least on that matter.
Thank you, sir. Are you here for Mr. Nate's
For Ms.
other cases as well?
Yeah, it looks like there's a total of 4 this morning.
Would you like to speak to Ms. Simpson this morning?
That would be great.
Ms. Simpson, you're going to see a button to join the attorney in the breakout room. Please join him to discuss this case.
Mr. Brown, can you hear me?
Yes,
What case are you here for this morning?
I don't know. I just saw a court date today.
Where's your
At
notice to appear,
8:59.
sir?
Huh?
Where's your notice to appear?
I don't know. I just looked it up online and it said appear on 8:55, so I'm here. And I just got a call from the 34th District Court. I'm here though.
What kind of case do you have, sir?
So OWI?
You're in the wrong place. The court clerk will look up where you're supposed to be and we'll get you into the right courtroom.
All right.
Stay put, please.
Sir, what is your middle name? Mr. Brown, what is your middle name, please?
Squire. SQUIRE.
Thank you. Give me 1 second.
This was a show cause that he was supposed to submit some paperwork to Virginia.
I already submitted.
I understand. I remember your name, sir. That's why
You're correct, Judge. He's supposed to be in contact with Stephen Hicks, the probation department.
Good morning, Mr. Coco.
Contact my probation.
You're muted. Mr. Brown, you're supposed to be with probation, not in the courtroom this morning.
Thank you.
You're so welcome, sir.
I think I'm unmuted.
You have unmuted. Who are you covering for this morning?
Terrific question. I'm here for the defendant on LVNV funding versus James Murney. So I'm here for Mr. Murney.
9:30.
9:30.
Okay.
Instruction said check in at
Yes.
9:15. Here I am.
I appreciate it. Thank you, sir. Good to see you.
Great to see you on the bench, Judge.
Mary Ann, that's an awful lot of people for there to be no matches.
I agree, Judge.
And this case with Ms. Kingsley has been adjourned now, I think 3 times. At least
Yes,
3
it has, Your
times.
Honor.
I understand. I think it was just an accounting issue that I had hoped to resolve today, but I'm not feeling.
Yeah, I had hoped to resolve it too, but I don't think the defendant is interested in resolving. So I have my property manager here to testify if they show up.
I'll call your case in 1 minute. Just
Thank
waiting
you.
for the 1:15.
Your Honor, we do have a match on a 9:15 on SMBMS versus Agubazi.
I know.
Okay,
I see you.
sorry, I
Let me
thought you
just
said
clear
we
up-
did. Just wanted to make sure
We
you knew
didn't,
we had
I'm
a
sorry.
match.
I appreciate that. You didn't have a match on the 9 o'clocks, and I still have some 9 o'clocks hanging around. I'll get rid of them, and then I'll get on to SMBMS. This is 211548 LT, Country Metals versus George Count. Appearance, please.
Good morning, Your Honor. Brianna Kingsley, PA 499, appearing on behalf of the plaintiff.
Thank you, ma'am. As previously indicated, today is the day and time set for the trial in this matter. It's been adjourned a few times. There had been a previous issue regarding the outstanding balance that was due to Country Metals from the defendant in this matter. It's scheduled for 9 o'clock. It's now 9:16 by the court's clock. Defendant having failed to appear. Ms. Kingsley.
Yes, Your Honor, at this time, we would request entry of a default possession-only judgment. Currently, rent to retain is $2,518.01. Cost of $158, making the total amount due and owing $2,676.01. We would request a writ to issue on or after August 13th of this year.
Inasmuch as the defendant has failed to appear for the duly scheduled trial in this matter, default judgment shall enter in favor of plaintiff and against defendant, writ to retain possession $2,518.01. Cost of $158 for a total of $2,676.01. Writ date August 13, 2021. Plaintiff to submit judgment to the court.
Thank you,
Anything
Your
else
Honor.
this morning, Ms. Kingsley?
I'm sorry, Your Honor?
I said anything else this morning?
I have one more at 9:30, so I'll just hang out.
Thank you, ma'am. This is 210182 LT, Lauren McKinney versus Tawan Tate.
Good morning, Your Honor. Robert Higbee appearing on behalf of Lauren McKinney, who's also present on the.
Good morning, Mr. Higbee. I asked previously if you had had the opportunity to speak to Mr. Hill. You indicated that you reached out to him yesterday.
That's correct, Your Honor. I sent him an email yesterday morning at 9:39, indicating that we had the hearing up today, that I would like to speak with him regarding this matter. And I did not hear anything after that time from him. And that was in response to an email he had sent me yesterday morning.
This matter was actually scheduled for review this morning. The parties had appeared on June the 1st, 2021 on the plaintiff's motion to lift stay. The matter had been stayed because of a filing in the circuit court. The last time we were here, the issue was that there was a motion for summary disposition pending in the circuit court, but had not yet been scheduled. The court asked for a 60-day review to see if there had been any activity or forward motion in the circuit court case. Has
No.
there been any, Mr. Higbee?
No, Your Honor, there's still not been a date scheduled. We have not even received so much as a scheduling order in that case from the circuit court, even though we were promised one months ago by the court clerk, by Judge Kenny's clerk. It baffles me why we are in this kind of limbo on that case, but it is clear that that case will extend for a significant amount of time, which obviously the court's aware was part of the basis for our motion to lift the stay. And I would renew that motion today, Your Honor. I think it's appropriate to lift the stay and set this matter for a bench trial.
Mr. Higbee, inasmuch as this matter was scheduled at 9 o'clock and is now 9:19 by the court's clock, neither defendant nor defendant's attorney have appeared this morning. The court will lift the stay in this matter. Do you believe the trial date is actually appropriate or a pretrial date?
I think you should set this matter for trial, Your Honor. I don't think there's, I don't think there's anything necessary to do other than proceed to trial in this matter.
Plaintiff's motion to lift stay is granted. Trial in this matter will be scheduled for August 31st, 2021 at 9 a.m. The court will mail out the notice regarding the trial. Mr. Higbee, if you would submit an order regarding your motion, the court would be most appreciative.
I certainly will, Your Honor. Thank you very much.
Thank you, sir. Have a good day. Have a
too.
good day, Ms. McKinney.
Thank you. You as well.
Are the parties ready on LVNV versus Simpson?
We are, Your Honor.
This is 212115 GC LVNV funding versus Renee Simpson. Appearances, please.
Good morning, Your Honor. Brian Gruen, Groen, P number 56673 on behalf of plaintiff LVNV funding.
Ms. Simpson, would you state your name for me, please?
Robin Renee Simpson.
Thank you. This matter was scheduled for pre-trial this morning. The parties have had an opportunity to meet in the breakout room. How are we proceeding this morning?
Your Honor, we did reach an agreement for a consent judgment on a reduced judgment balance as long as Ms. Simpson faithfully makes these payments and doesn't default. We will accept a total of $440 payable by $25 payments to begin on September the 7th of 2021. And we did get email authorization from her, so I will be emailing the consent judgment to her. And then once that's returned, we will get that signed and entered with the court.
Judge, I do have Ms. Simpson in the court now. If he could email it to me, I could get her to sign it.
Thank you, Sandy. I was going to suggest that. Ms. Simpson, were you able to hear what the attorney just said regarding the balance of $440 payable at $25 per month?
Yes, ma'am, I did.
And that's your agreement, ma'am?
Yes, ma'am.
With the $25 per month to start on September 7th, 2021?
Yes, ma'am.
Mr. Groen, if you're able to get that consent judgment emailed over to the civil department, if you don't have the email address, Sandy can send it to you in the chat. She'll have Ms. Simpson sign it and return it to you this morning and we can get it entered.
Unfortunately, Your Honor, I have multiple hearings, so I'm not going to be able to get to the drafting of consent anytime soon.
No worries.
Okay,
We
yeah.
tried. Ms. Simpson, just check your email for the consent judgment from plaintiff's attorney, and once you sign it, get it back to him. He'll sign it, send it to the court. Court will sign it, you'll get a copy, okay?
Yes, ma'am.
And
Mr.
Mr.
Groen,
I will
I'm
send,
sorry.
I will send you the rest of the payment information in the email I send to you, okay?
Okay, thank you, Mr. Groen.
Thank you.
Anything else on behalf of the plaintiff?
Nothing, Your Honor.
Anything else, Ms. Simpson?
No, ma'am.
Thank you for coming in this morning, ma'am. Have a wonderful day.
You too. Thank you.
Thank you. This is 211303 GC SMB MS Inc. versus Agubosi.
Morning, Your Honor. Robert Iggerson on behalf of the plaintiff.
Good morning, Your Honor. Augustine Igwe on behalf of the defendants.
Good morning. Today was the day and time set for the final pretrial in this matter. Are the parties ready to proceed?
Your Honor, plaintiff served defendant with discovery on June 28, and I haven't received a response from that. Sent it to him by email. I'd like to get an order compelling.
Your Honor, the response will be ready by this Friday, and that should not be a problem.
That's acceptable, Your Honor. The only issue is how complete the answers will be. maybe we should pre-try this again.
Are you looking for a new pretrial date or are you looking to have a conversation this morning?
A new pre-trial date. I need to see his records.
Thank you, ma'am. The new pretrial date will be September the 14th, 2021. I don't have a time. Mary Ann or Sandy, do you have a time on the 14th?
Yes, we can do 9:30.
I assume by
9:30
Zoom.
on September 14th?
That's fine. I'm guessing by Zoom.
By Zoom, of course, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Anything further on behalf of the plaintiff?
Nothing.
Anything further on behalf of defendant?
No, Your Honor. Thank you very much, Your Honor.
Thank you
Thank
much.
you.
See you back here on the 14th of September.
Thank you, counsel.
Bye-bye.
Bye-bye, Your Honor. Good to see you.
Good to see you, sir. Good morning, Mr. Harrington.
Good morning, Your Honor.
Have you had a chance to speak to Ms. Kadapa?
Yes, we spoke, we most recently spoke late yesterday afternoon.
Then let me
I
call,
have
I'm
not-
sorry, let me call the case 211018GC, Wolverine Orthotics versus Carla Kadapa.
Good morning, Your Honor. John
Appearances.
Harrington, on behalf of the plaintiff.
Thank you. Ma'am, would you state your name for me, please?
Carla Kadapa.
This matter was scheduled for pretrial and the plaintiff's motion for a more definite statement this morning. Sir, you were saying that the parties have had an opportunity to speak?
Yes, as of this moment, unfortunately, I have not heard back from Ms. Kadapa. We proposed a settlement offer to her, but I presume that it's not acceptable because I have not heard back from Ms. Kadapa by this morning, so.
No, we had one too, and they didn't accept it either, so.
Do the parties need to go into a breakout room this morning to speak regarding an offer or a response to an offer?
I don't think so, Your Honor, to be frank. I think Ms. Kadapa's comments just kind of solidified that our demand most recently was not acceptable, so.
Unfortunately. Oh,
Okay. Well, the other outstanding matter is the plaintiff's motion for a more definite statement. Ma'am, did you receive a copy of that motion?
yes, I did.
Did you submit a response to it?
No, I did not. I mean, we were hoping that we could settle it, but didn't happen. So I guess we're gonna have to get an attorney.
Ma'am, who are you speaking to?
You.
Nope, you're looking off to your left.
I was talking to my husband. I'm sorry.
That's okay. I wasn't sure if you were indicating you were getting an attorney or you were asking your husband
I was
what
kind of
you were going to do.
Okay. Well, we've got to respond to the things that he said. So we've got to either get an attorney or respond to him.
Okay.
So we need to get an attorney then. She needs to know what the next step is.
No, I'm asking because there's a motion for a more definite, a more specific answer to the complaint.
Okay.
Did you receive the plaintiff's motion?
We got a copy. I don't know.
That would have been back in June sometime.
What did
Is this it? Yeah, isn't it? He's talking about, this.
Ma'am?
Yes. Yes, I did
The
get it.
plaintiff- Okay. And did you submit any response to it?
No, not since the first thing that I responded to. I did not.
Did you read the motion?
Yes, I did read it.
Did you understand what what Mr. Harrington was requesting?
No.
Ma'am, you received a summons and complaint in this matter. The complaint are the specific allegations that the plaintiff is making. You are supposed to respond to each one individually. As to paragraph 1, admit, deny, or no response for whatever reason. As to paragraph 2, same thing. What you submitted to the court and what the court accepted as an answer is a letter.
Okay. That's what I get. Yeah, that's the first thing that I gave.
Okay. Mr. Harrington, as to your motion?
Well, Your Honor, as the court just summarized, the court rules require that in a response to pleading, there be a response to each and every allegation contained in the paragraphs. I simply, and Ms. Kadap, I understand she's in pro per, but she still didn't respond to each and every allegation. So I'd ask the court to require Ms. Kadapa to file a more definite answer, a more specific answer, a more definite statement within 14 or 21 days, and then we can allow this matter to go forward.
Okay.
Ms. Kadapa, within the next 3 weeks, are you able to file a more definite statement in response to the summons and complaint in this matter?
Yes.
Yes.
Court will grant the plaintiff's motion. The defendant has 21 days to file a more specific answer, a more definite statement in response to the summons and complaint in this matter. Ms. Kadapa, based on the fact that the amount listed in the complaint is about $700.56, I would suggest that between now and the day that your answer is due, you make some effort to maybe discuss this matter again with Mr. Harrington's office and see if the parties are able to reach an agreement. Court is not trying to force a settlement. I'm just saying, based on where we are, and this is being our second appearance and facing a third appearance on September 14th, that we might think about the best use of time and resources in this matter.
I understand that. We offered half of what the settlement is.
I understand, ma'am.
And basically right now with my husband still doesn't have a job.
That information might be beneficial to Mr. Harrington, and there might be a payment plan that the parties discuss on a reduced amount. The court does not know. I'm just suggesting that you might want to consider a conversation. Mr. Harrington, if you would submit an order granting your motion and giving the defendant 21 days to submit a more definite statement in response to the complaint, the court will adjourn the pretrial to September the 14th at 9:30 a.m. It will again be by Zoom.
I'll prepare it this afternoon and have it sent to the court. Thank you very much.
Thank you. Anything else, Mr. Harrington?
No, Your Honor.
Anything else, Ms. Kadapa?
No.
Have a good day, ma'am.
Thanks, you too.
Have a good day, Your Honor. Goodbye.
Thank you. Mr. Hill.
Morning, Judge.
Hi, what happened to you this morning? We missed you.
Judge, I'll be honest with you. I got an email from opposing counsel about a status conference. So I was sitting in Judge Kenny's courtroom in the circuit court matter, waiting for a status conference when I read my calendar and it said to be here. So I literally logged in because there's a competing case for quiet title in circuit. So it's my error.
I called the case at 9:19. He renewed his motion to lift stay. I granted his motion and set this matter for trial on August 31st at 9 a.m. When the file showed back up last week, I looked at the circuit court case ROA and saw that nothing has happened since we first stayed this matter back in February.
I understand, Judge. Mr. Higbee's been very proactive. It's just the circuit court has not. And I'll be honest with you, I feel sorry. I feel sorry for him. I mean, he filed his motion. It should have been scheduled. So I understand the court's ruling and I respect it. Now I'll talk to Mr. Higbee potentially about a resolution.
Thank you, sir.
No problem. Thanks, Judge.
Have a good day. I saw him pop in. Thank you, Mary Ann. Oh. Who is this with the ceiling, with the floor tiles?
I haven't been able to, oh, there we go. I don't know.
Oh, I recognize. I know this case. I know this lady. Ma'am with the pink shirt, what is your name, please?
I was supposed to have an
Sir,
attorney
and-
this morning. I haven't took it down, but
Ma'am,
yeah,
what
I'm
is your
trying.
name,
I'm on
please?
the phone with Christina Maddox.
Thank you, Ms. Maddox. To the gentleman in the car,
Yes.
your name? Good morning.
Good morning. How are you? I'm sorry. I'm working, just getting up. My name's Tyrell Givens.
Mr. Givens, thank you. We're not quite to your matter yet. Give me one. We have you checked in. If you stay put, we'll get to you in just a moment.
Okay. You're
Thank you.
welcome.
Mitchell.
Your Honor, may I speak to Mr. Givens in a breakout room?
Absolutely. Mary Ann, if you would facilitate that.
It's an eviction. It's an eviction.
Mr. Givens, you're going to see an invitation to join the attorney in the breakout room. Please join her.
Okay.
This is 211837GC, LVNV funding versus Belita Mitchell, AKA Belita Coleman.
Send it to voicemail.
Good morning, Your Honor. Brian Gruen on behalf of LVNV Funding.
Give me 1 second. Why are you hiding back here? You're not camera ready. I see the attorney here. Thank you, sir. I'll call in just a bit. Sorry, Mr. Gruen. I
That's
had an
okay.
unexpected visitor. Have you seen or has your office had communication with Ms. Mitchell?
We have not, Your Honor.
This matter was scheduled for pretrial at 9:15. It's now 9:37 a.m. by the court's clock. Defendant having failed to appear, sir, how do you wish to proceed?
Your Honor, if it's fine with the court, I would suggest that we be allowed to file a default judgment under the 7-day rule.
Default judgment, what's the principal damage, sir?
The charge-off balance on this credit card was $990.47. We have court costs totaling $106.12 for a total judgment of $1,096.59.
Inasmuch as defendant has failed to appear for the duly scheduled pretrial, default judgment will enter in favor of plaintiff and against defendant. Principal damages of $990.47, court costs of $106.12 for a total of $1,096.59. Plaintiff to submit judgment pursuant to 7-day. Anything else in this matter, sir?
I think that covers it, Your Honor. Thank you.
Thank you. 211964GC, Citibank versus Terry Shunith. Thank you. Appearances, please.
Good morning once again, Your Honor. Brian Gruen, Groen, key number 56673 on behalf of plaintiff Citibank.
Your name, sir, for the record?
Terry Shaneth.
Mr. Shannon, thank you, sir.
You spell that? Good luck.
This matter is scheduled for pretrial this morning. Have the parties had an opportunity to speak?
Your Honor, we have. The defendant is working with a debt settlement company by the name of AmeriCorps Financial. So they have sent our firm a copy of the power of attorney on behalf of the defendant. We're asking for an adjournment maybe to the next available day. It sounds like it's September the 14th to give the party some
It is.
additional time to hopefully reach a settlement in this matter.
I agree.
Thank you.
Judge, could
That
we
is
do,
correct. Our next, I'm sorry.
we do these at 9:45 now?
That was the time I was gonna give. Thank you, Sandy. We're gonna adjourn the pretrial to 9/14/2021 at 9:45 a.m. Anything else on behalf of the plaintiff?
Nothing, Your Honor.
Anything else on behalf of the defendant?
No, we're going to try to work this thing out.
Thank you, sir. You have a wonderful day.
Thank you. Same to you, Judge.
Thank you. Good morning,
Thank
Mr.
you.
Nunley. Andy brought the files up, but I haven't seen Huron yet. Have you had the opportunity to speak with the defendants in these matters?
No, I have not. I was supposed to meet him here. I did talk to the officer at the station, and she said she needed about 5 minutes to get him there about 5 minutes ago.
As soon as they pop on, Marianne will move you right into a breakout room with them, and I'll try to get the civil docket finished.
Thank you.
Thank you. This is 211042 GC Garden City Family Dentistry versus Kayla Johnson.
Good morning, Judge. J. Latif Beg, BAIG, P 36820, appearing on behalf of plaintiff and the attorney of record.
Good morning. I have not seen Ms. Johnson this morning, but the civil clerk just brought in an executed consent judgment with Ms. Johnson's signature that indicates that $4,250 is due in damages, court costs of $147.50, statutory attorney fee of $75 for a total of $4,472.50. The signature by the defendant on the consent judgment matches that which appears on the defendant's answer, and it's signed by Christopher Sosong of your office.
Okay, if that's the case, then let's find Christopher Sosa.
That's what it looks like. He just brought it to me. It's not dated. I'm not sure when the civil department received it.
We just received that today, Judge.
Thank you, ma'am.
Very-
And in
very
as much as Ms., I'm sorry.
Yeah, then very good. It's just a consent judgment without payment terms.
There are no terms on here.
Okay.
In as much as the fully executed consent judgment's been received by the court will sign the same. Civil department will mail it out to the parties.
Thank you, Judge.
Anything else this morning?
No.
Have a good day, sir.
You too. Thank you.
Thank you. 212064 LT GNI 9 Harbor Club property versus Tyrell Gibbons.
Good morning, Your Honor. Brianna Kingsley, PA 4929, appearing on behalf of the plaintiff.
Mr. Gibbons,
Yes,
state your name for me, please.
Tyrell Givens.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the stay. The parties had previously appeared in this matter. On May the 26th, 2021, the defendant indicated that he was making an application for Sarah funds, financial assistance with the past due rent, in order to stay pursuant to Administrative Order 2020-17 went into effect. It has now been more than 45 days since that stay was put into place. Plaintiff did file the request to lift the stay. Court received it on July 20th, 2021, indicating that payment in full had not been received from Sarah, asking that the stay be lifted and the pretrial be scheduled. The parties have had an opportunity to speak this morning. Ms. Kingsley, how are we proceeding?
Yes, Your Honor. At this time, we would request one final adjournment. I have Mr. Givens' caseworker information, so I'm going to reach out directly to them at Wayne Metro to try to figure out if his application will be processed anytime soon.
If I put you over to our August 31st date, will that give you sufficient time?
That's fine, Your Honor. Yes, thank you.
And as much as the plaintiff has not received the payment from the HARA on the SARA funds, the court will lift the stay and schedule a pretrial for August 31st at 9 a.m. Marianne, I know it's a trial at that time, but I'm guessing that this would be a relatively quick matter. Anything else on behalf of the plaintiff?
Not at this time, Your Honor. Thank you.
Anything else, Mr. Givens?
No, I can't really, no, because I haven't even really got my Sarah app taken care of. I'm at work right now, so I'm still trying to take care of everything. So
Understood. Well, we're all set in this matter. Mr. Givens, we'll see you back here on the 31st. It seems as if Ms. Kingsley will make some effort to follow up with Wayne Metro and figure out what needs to happen to kind of get the application completed.
Well, Your Honor, Mr. Givens, I'll reach out to you as well once I hear from them, okay?
okay, thank you very much.
Bye, Judge. Thank you.
Bye-bye. I have not seen Phil Greenblatt for the 9:30 case. It's 9:46.
I thought I saw his name on there, Your Honor.
Oh, he's dark. Wait, I see him. Thank you. You saved him because I was going to roll right over him.
I was looking for him too, Your Honor.
212. Oh, I'm sorry. Kurt Coco said it, and I'm looking for Phil still. 212116 GC LVMV funding versus James Murney. Appearances, please.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff LVMV funding.
And good morning, Your Honor. Attorney Kurt Coco, P 54468, appearing in place of the attorney of record and for the defendant.
Thank you, sir. The matter is scheduled for pretrial this morning. Have the parties had an opportunity to speak?
We have not, Your Honor. We work with Phil's office quite often. He works in conjunction with a debt settlement company as well. So if the court is amenable, I would say if we could just adjourn this pretrial out to that September 14th date. I'm hoping the parties, especially Phil, will reach out to us and see if we can resolve this matter in that time frame.
Mr. Coco?
That's acceptable. Would discovery be open until that time?
If you request it.
I would like to request discovery at this time, Your Honor.
How much discovery do you need?
60 days would be ideal.
Mr. Braun? As
I
to
have no-
discovery, any objection?
I have no objection to that. Then I would say let's not do the 9/14 date then.
That's what I was going to suggest. That puts us over to, give me 1 second. Mary Ann, I see here on here, if you would move them into a breakout room with Mr. Nunley.
Yep, they're already there.
Oh, thank you, ma'am.
Welcome.
October 5th. Why does that sound like a bad day? What's going on that day?
Yes, Judge, you gave me, you gave me. That's the date you gave me.
That is a good day. Well, Mr. Braun said with a 60-day discovery, that takes us beyond where we need to be. So we'll put them on the October 5th docket. Pretrial will be adjourned to October 5th, 2021 at 9:45 a.m. Discovery open for 60 days. Mr. Coco, would you submit an order opening discovery for that period of time, please?
Sure, Judge.
Thank you. Anything else on behalf of plaintiff?
I don't believe so, Your Honor.
Anything else on behalf of defendant?
Just, and forgive my ignorance, but do I submit that order by just traditional mail, first-class mail?
First class mail or email, your preference.
Ideal. Thank you very much, Judge.
Thank you. Have a good day, sir.
Thank you, Your Honor.
Ms. Bell,
Yes.
211885 LT Barrington Romulus Apartments versus Dominique Bell. Turn your video on for me, please, ma'am.
Okay, give me 1 second. Yes.
This matter was scheduled for the plaintiff's request to lift the stay, I believe. Nope, sorry. Was scheduled for an adjourned pretrial. The court received a dismissal from the plaintiff's office this morning. Had Mr. Katz or anyone from his office communicated that to you, that the matter was being dismissed?
No.
Okay. Did Sarah pay your past due rent?
Yes.
Okay. In as much as your rent's been paid, I guess to plaintiff's satisfaction, they have submitted a dismissal to the court. Unless you have any objection, the court will sign the dismissal.
Okay.
Okay, Ms. Bell, we're all set. The civil department will mail a copy of the signed dismissal to your attention.
Okay, thank you.
Have a good day, ma'am.
You too.
Thank you. Marianne, you are wonderful. I stand up, I see Mr. Nunley and Huron, and you move them in, and next thing you know.
It goes downhill from here.
You said what?
It goes downhill from here.
No, it's not gonna go downhill. We're cooking with gas. We're doing our 10 o'clock hearing. I'm looking for my other 10 o'clock. This is this is the one where Mr. Schisler's office did not appear the first time. I'm hoping he's not in the wrong place. Our 10 o'clock, 10:30 cases here. I'm waiting for our criminal cases to come out. Ms. Maddox, your case is not until 10:30.
Mary Ann, if you can hear me, we got kicked out of our breakout room.
Yes.
Okay, yep, I'll put you back in.
Thank you.
Welcome.
Mary Ann, there are 3 Hurons and 1 Sumter, is what the
Okay.
story is.
Thank you.
Thank you. Mr. Stanford? This is 210929 GC Gateway Financial Solutions versus Stanford.
Yes,
State your
ma'am.
name for me, please.
Salahuddin Stanford.
Mr. Stanford, we were here first on July 6th, and plaintiff's attorney was in the wrong courtroom. The matter was rescheduled for today at 10 o'clock. I usually do the defaults at about 15 after, so if you can sit tight for about 14 more minutes.
No problem.
Thank you, sir. Okay. Mary Ann Romulus just came on. What time are Sumter? Did Sumter say or Romulus say? Look at you.
So Sumter and Huron,
Are
the Sumter
together.
case is at Huron.
Okay.
So, all four of those are gonna be the same thing on Zoom.
Okay.
And then Romulus will be separate. So I told Royce to let me know when you guys are done with the Huron ones, and I'll call Romulus and have them join.
Okay.
But either way, because I didn't want to have them join now, because I don't know where you guys are at with everything.
We're waiting for, we have a 10:30 trial and an 11 o'clock trial.
Okay.
So if they came on, I could do it, but I know Royce needs to talk.
Right. Royce got to talk to everybody except for that one guy who might change his mind. I don't know.
He's here. Royce is already in with them.
Okay.
So,
He's probably going to talk to them
Yeah.
all.
which is
first.
fine.
All right.
Okay. Thank you, ma'am.
Yeah, I don't know what's in the water today, but
It's a beautiful Tuesday.
is that why they all got in trouble? All got picked up?
We call it the circle of life here.
Yeah. If you need anything else or need me to call anybody, just let me know.
I will. Thank you, Andy. I think this is just money. Was that sufficient time, Mr. Nunley?
Well, the one person that's from Sumter, they're not sure what's going on with him, so the officer just went to check to see if they're going over. I mean, the three people that are in that room, I guess we could go ahead and do those, and then I could do Sumter.
I just talked to Sumter. They're on an investigation right now. They said I can assist in the rating. So if you want to speak with him,
Judge,
you want me to do that?
It's up to you. You want me to talk to him and do all four at the same time, or you want to do these three and then have me go in a breakout room with the other one?
Let me do these three because I have a 10:30 trial schedule and Romulus has one on as well.
Okay.
Not on, but queued up for you. This is 210622 SM, State of Michigan versus Hugh Anthony Dark Jr.
Yes.
Royce Nunley appearing on behalf of the defendant. We would waive a formal reading and ask the court to plead not guilty on his behalf.
Sir, would you state your name for me, please?
My name is Hugh Dark.
Thank you.
You're welcome.
Today is the day and time set for your arraignment. Mr. Nunley has already indicated a plea of not guilty in this matter. Court will indicate the same. As for bond, there is a recommendation from law enforcement for 20,000, 10%. Mr. Nunley, what say you in response to this recommendation?
Well, I think that the recommendation seems high. I think that it's not a bad case for a personal bond. We've got a couple outstanding issues. One is just fines and costs. And he indicated to me that he was trying to make his payments. He broke his leg, had to have emergency surgery, ended up messing him all up financially. The other outstanding case is for like a dog license. And he claims that he never received any sort of notice for the dog license case. I explained to him that along with the domestic violence, there would be a strict no contact. The alleged victim is his son. They live in the same home together. He's indicated that he's got a place to go. He understands that he's not going to be able to go back and that he's not going to be able to, make contact with the alleged victim. I don't think that he's a flight risk. He seems that, he seems eager to get this stuff taken care of so that he doesn't have it hanging over his head. So I'd ask the court to consider a personal bond in this matter.
Thank you, Mr. Nunley. In as much as law enforcement has indicated that there is a prior conviction for domestic violence, the court is going to set the bond at 5,000, 10% with a no contact with the alleged victim in this case, that being Jacob Dark. And Mr. Nunley, you've indicated that Mr. Dark has somewhere else to go.
Yeah, he said that he did have a place to go.
So the not returning to the 19124 Craig Street address won't be a problem for him?
That is correct.
Thank you. So no contact with the alleged victim and do not return to the address where the incident is alleged to have occurred. Mr. Dark, your next appearance date in this matter will be a pretrial on August the 18th, 2021 at 10:45 a.m. and that will be back with me by Zoom.
Okay. I think you said I had a prior domestic violence. I've never had a domestic violence charge.
I hear you, sir. I'm looking to see where Huron received that information.
I'm double checking as well, Your Honor.
Thank you.
I see one that says 11/18 of 2004, Romulus Police Department.
That's my wife. Against me.
And that case appears to have been dismissed. Thank you for pointing that out, Mr. Dark.
Sure.
5,000 personal. The other conditions remain: no contact with the alleged victim in this case and do not return to the Craig Street address. Your date does not change. You still are to be back here on August 18th, 2021 at 10:45 a.m. There are, the other outstanding matter is 20HR 06403OM. This is the no dog license case from July 15, 2020. Mr. Nunley has indicated the same in these matters. Bond in this matter will be set at 1,000 personal. Your next appearance date will be a pretrial with Judge Oakley on September 9th, 2021 at 8:30 a.m. The third case was 172823 OT. This is a allowing person to drive in violation of vehicle code. from June the 30th, 2017. This is a matter of payment. Mr. Dark, you owe the court a total of $720 in this case. I would ask that you contact the court's collection department. You can go online and submit a request for payment, or you can contact the court to reestablish a payment plan in this matter.
Okay.
Anything else asked to Mr. Dark, Mr. Nunley?
Nothing further, Your Honor.
Thank you. We're all set, Mr. Dark. Thank you, sir. We'll see you back
Thank you
here
very
on the
much.
18th.
Your Honor, my apologies for that confusion. I wasn't the one that did the bond rec, but I should have double checked. So my apologies on that.
No worries, sir. Thank you very much.
No problem.
Mr. Lewis. This is 210623 SM, State of Michigan versus John Howard Lewis. State your name for me, please, sir.
John Howard Lewis.
Mr. Lewis, the court has received this matter for arraignment this morning with an indication that you choose not to speak to the court-appointed attorney in this matter. Is that correct?
I just thought I could explain this myself.
Mr. Lewis, we're not at the explaining part just yet. This is the arraignment. This is the first appearance where are read your charges and you enter a plea of guilty, not guilty, or you stand mute. Do you still wish to not speak to the court-appointed attorney?
Well, maybe I should talk to the attorney then, because I don't know.
It's fine, Mr. Lewis. If you want to speak to Mr. Nunley, we'll do that, but there's one other matter that he's already spoken to. You've already spoken to Mr. Wright, correct?
That is correct.
So, Mr. Lewis, if you would just change places, we'll
Okay.
get Mr. Wright taken care of, and then you'll get a chance to talk to Mr. Nunley.
Let's see.
This is 21HR08577 A, B, and C, and 20HR12885 A, B, and C. Appearance, please.
Royce Nunley appearing on behalf of the defendant. We'd waive the standard reading the application to the plea of not guilty.
State your name for me, please, sir.
Raylan Wright.
Mr. Wright. Mr. Nunley has indicated that you will be standing mute in a plea of not guilty. I'm sorry, waive the reading of the charges in this matter. The 21HR08577 A, B, and C, your driving while license suspended, no proof of insurance, and a speeding 16 to 20 over the limit. The next hearing in these matters will be September 20th, 2021 at 10:10 a.m. with Magistrate Al Hinman. There is a bond recommendation for $5,000, 10% from Huron Township Public Safety. Mr. Nunley, do you have any comment on the bond?
Yeah, I'd ask the court to entertain the idea of a personal bond. These are driving issues, right? He's got some problems with his license that he needs to clear up. The older charges seem to be, pretty much the same as the newer charges. There was a driving while license suspended and an insurance issue, and then a speeding ticket. Mr. Wright is not on probation or parole. He's working full-time right now at some sort of plant that I guess is across the street from you guys. He does have 3 children who he is helping to support. I told him, I was very clear with him that, he needs to comply with the court's orders of peer to get these things taken care of, or else, these warrants are just going to keep being issued and the money is just going to keep adding up. He understands. He wants to get him taken care of. He doesn't want to lose his job. He doesn't want to fall behind. So I'm confident that he plans to appear and to participate in any future court proceedings. So I'd ask that you entertain the idea of a personal bond.
Mr. Wright, how long have you been on your job?
2 months.
And you're responsible for the financial support of whom in addition to yourself?
Yeah, my kids.
Are you their sole source of support?
No, their mother.
Your bond's going to be set at 5,000 personal. Again, your next date in all six of these matters will be, hold on. Yep, September 20th, 2021 at 10:10 a.m. September 20th, 2021 with the magistrate Al Hinman. Anything else in these matters, Mr. Nunley?
No, Your Honor.
We're all set, Mr. Wright. And if you could talk to Mr. Lewis, I see that part of the 10:30 trial is here.
Okay.
Thank you, sir.
I'll be right back, Judge.
Thank you, ma'am. I have not seen Mr. Robinson this morning, but Miss Maddox had been here. I don't see her right now, but she had been here.
I just talked to Robertson and he should be getting online shortly, ma'am.
Thank you, ma'am.
Thank you.
Two 210929 GC Gateway Financial Solutions versus Stanford. Mr. Stanford, thank you for your patience again this morning. As the court previously indicated, this matter had been scheduled for pretrial back on July the 6th, 2021. Neither party appeared originally. The court indicated the matter would be dismissed. Then plaintiff's attorney appeared at 11:20 a.m. indicating that he had been in the wrong courtroom, so the matter was rescheduled to today at 10 a.m. It is now 10:18 by the court's clock. Plaintiff's attorney has failed to appear. The matter is being dismissed. Any objection to that, Mr. Stanford?
Not at all. Thank you.
Thank you, sir. Have a good day.
You too.
Good morning, Mr. Robinson.
Good morning, Judge. How are you?
I am wonderful. How are you?
Good, Judge. I'm sorry. My notice here says 10:30.
Correct.
Oh, okay. You know, I just finished a friend of the court or a circuit court matter, so I apologize.
No, you're fine. There are some arraignments that came on, trying to get those done before your 10:30 and your 11 o'clock. Would it be beneficial to you to speak to Ms. Maddox this morning, or have the parties already had an opportunity to speak?
I don't think it would be beneficial, Judge, at this point.
Okay.
Judge,
Man, sir. Are you kidding me? I'm sorry, Mr. Robinson?
Judge, on second thought, maybe it would be beneficial if you did put us in a breakout room briefly.
Excuse me. I am going to put you into number 1. Ms. Maddox, you're going to see an invitation to join the attorney in breakout room number 1. Do you want your client in as well, sir?
I do, Judge. Thank you.
Okay. You should see your invitations.
I'm back, Judge.
I just moved Mr. Robinson, his client, and Ms. Maddox into number 1. Mr. Schishler,
Yes, Your Honor.
are you here for Gateway Financial?
I am. I apologize. I was sitting in Judge Oakley's Zoom thing and then realized and called the court. I was looking at a previous notice that had a court ID that was wrong. So I apologize.
This is the second time that this has happened, and I just dismissed the case again. I'm going to give the file to Mary Ann to see if we can get the defendant on the phone. He just logged off within the last 4 minutes.
Yeah, I apologize. It was my partner on last time, and so I just realized it. You know, he was supposed to do the hearing and
Well, your matter is
Not an-
scheduled for 10 o'clock. I just handed the file back to Mary Ann to see if she can get him back on the phone. If so, great. If not, I have a 10:30 and 11 o'clock trial. So sit
Not a
tight,
problem.
mute yourself, and hopefully we can get him back on.
all right.
Thank you. I wouldn't. If he doesn't, I'll just reschedule it. No. August 31st at 10 a.m. Mr. Schishler,
Yes, Your Honor.
he's not answering. I will have the court send out a notice.
I'm going to reach out to him again to see if I can resolve it. I've tried in the meantime. I'm hopeful based on the language of his answer, but I haven't been able to get a hold of him.
Well, what I'm going to say is August 21st at 10 a.m. And that's back with Judge Martin. No excuses.
I hear you, Judge. It's my fault.
Thank you, sir. No, it's Zoom. At least you're in the right court. Wrong judge, right court. See you back here on the 31st.
All right. Thank you.
Thank you. Sorry, Sandy.
Thank you, Judge.
Mr. Maddox, you're back with, I'm sorry, Mr. Nunley, you're back with whom?
Well, I need to go back into the breakout room. I finished Mr. Lewis, but I still have to talk to the last individual.
Mr. Gamble? Okay.
Yeah, we have him right here, Your Honor.
Mary Ann, you should be able to just rejoin number 2. Mr. Robinson, was that sufficient time with Ms. Maddox? Oh, no, okay.
Sorry about that.
Mr. Robinson, was that sufficient time with Ms. Maddox? You're muted.
You're muted.
Yeah, I got it.
You like my little sign, Judge?
I love it. Thank you.
But Judge, my client knows me all too well. That's the problem. Ms. Maddox obviously is having technical difficulties because we can't see her and then her audio went. So I haven't been really able to speak to her. I don't know what the issue is.
I can hear you now.
Okay, can you put us back in the breakout room?
You should be able to go back into number 1.
Your Honor, I asked for a court-appointed attorney. Do I have one?
You asked for an attorney
The last.
when we were here back on July the 21st, correct?
Yep, and they were supposed to give me a.
And I asked you at that time, had you received the information sheet from the court? And you indicated that you had called Lakeshore or you called Legal Services and the day before the hearing or maybe a couple of days before the hearing?
No.
This is 212629 LT Royal Village versus Christina Maddox.
Yep.
Appearances.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of the plaintiff, Royal Village.
And I was supposed to have an attorney. Okay.
Ma'am, you were supposed to contact the Legal Services based on the information that was included with your.
I asked for no, I didn't get anything that said anything about contacting an attorney.
Judge, my understanding is at that last hearing and having many cases with you, I'm sorry, Ms. Maddox, is that she had asked for more time to get an attorney, which has brought us to this adjourned date.
Yeah.
So.
And then she had said that she had already left a message with an attorney that she hadn't talked to them yet on that day.
No, I did not. No, I did not.
Ms. Maddox, we are not on the corner. We do not just yell things out. And what I was starting to say before was, I remember this case. You indicated that you wanted an attorney. I indicated to you, as I do as a standard practice, that the court does not appoint attorneys in civil cases. I asked you, had you received the information sheet when you were served with the summons and complaint in this matter? You indicated that you were, and that you had contacted Legal Services and left a voicemail and had not heard back from anyone. Based on that, the court adjourned this matter to today to allow you time to follow up with Legal Services. There was no indication from this court that the court would assign or appoint an attorney to you in this landlord-tenant matter. Now you may respond. Did you receive any response from the Legal Services office?
No.
Have you made any follow-up calls to them?
There's only a yellow sheet that came with my thing and there is no response from them.
My question to you was, had you followed up? And you're saying, no, you had not called them again since the July 21st hearing?
No, I mean, after the hearing, yes, but no, I have not heard anything from them.
So how do you intend to proceed this morning?
I mean, I wanted an attorney. Because apparently she's going to fight me on this and saying things that aren't true, and I would like to have an attorney.
And ma'am, when you received the notice to quit back on February 19, 2021, the defendant copy or tenant copy of this notice provides contact information for assistance. You then received the summons and complaint on this termination of tenancy matter back on June the 25th or so, which would have included the yellow sheet for you to contact Legal Services.
Your Honor.
You then had the July 21st appearance date where the court again indicated to you that it's your responsibility to contact Legal Services.
Your Honor, the first.
This matter is scheduled this morning on your termination of tenancy. First off, okay.
Okay, when she put the notice on my house, she put it on the outside front of my house when it was pouring down rain. So there was nothing to read on that notice, okay? And I had to come to my court hearing, all right? And I have that at home. And then I received a second one after the court hearing for the new court hearing with the yellow paper, which I contacted. I asked for a court-appointed attorney at the last hearing, and I still have not heard anything back from them. Because I need an attorney to deal with this because she's not being honest. She's not being forthcoming with you guys. And I don't want to fight with her. And it's a big fight because I mean she's been calling everybody in my trailer park, telling them not to let my son do work at their house. I mean she's been doing all kind of stuff to go outside of this. It's like ridiculous. I want to stay where I'm at. I have cancer, and yes, he is my caregiver, and he does come to my house on a daily basis to take care of me, but he's living on Statler Street in Taylor. And he does come to my house on a regular basis to take care of me. And this is the whole problem with her. She does not like my son, period. She doesn't like him. And when she doesn't like someone, she goes out of her way to make sure that she knows that we don't like them. She's caused problems in the trailer park. We're calling everybody in the trailer park, telling them not to let him cut their grass and all kind of stuff because he has a little lawn care business. She's calling tenants in the trailer park saying, don't let him cut your grass. Don't let him do this. Don't let him do that. This is how I have witnesses to all the stuff that she's been doing. I mean, I don't try to fight with my landlady. I don't try to do anything. I try to stay to myself. I'm sick. I try to stay out of her way. I don't do anything to cause a problem in my park. I have not done one thing to cause a problem in my park. She has the problem with my son. And he's 21 years old. She has a problem with him, not with me.
Ms. Maddox, this is the same path we went down last time, when the court inquired whether or not you wanted counsel,
I did want counsel.
You launched into what was going on at the park instead of answering the question.
Yes.
The court has a very specific memory of this case, and the fact that my standard practice is to say you're responsible in the landlord-tenant cases for reaching out to attorneys. You received the notice to quit back in February. That was 6.5 months ago, which would the tenant copy of that notice provides contact information for legal resources. You were then served in this case. You have now had ample time to reach out to legal services office and either get advice and counsel or secure representation. You have had more than enough time to try to access resources. This matter is scheduled for hearing this morning on the termination of tenancy. Are you ready to proceed?
I mean, I guess I had to proceed without an attorney. I mean, I wanted an attorney.
What have you done in the last 2 weeks to secure an attorney?
Left a message for the attorneys. That's it.
Left a message?
Yes, ma'am.
Mr. Robinson?
Judge, as I had indicated before we came back on the record again, in the breakout room, Judge, in the breakout room, I was going to propose something to Ms. Maddox until her phone wasn't working. So if the court, trying to facilitate this, Judge, if the court could put us back in the breakout room, I'm going to see if I can resolve this. If you don't mind.
Number 1 is still open. If you would return to courtroom number 1, breakout room number 1.
Okay,
Ms. Maddox, please rejoin the attorney in the breakout room.
Yes, ma'am.
Mr. Nunley.
Can you put me back in the breakout? Can you send me the breakout room?
This is 210623 SM, State of Michigan versus John Howard Lewis.
Royce Nunley appearing on behalf of the defendant. We'd waive a formal reading and ask the court to enter a plea of not guilty on that.
Mr. Lewis, are you able to hear the proceedings this morning?
Yes, ma'am.
Okay. Waive formal reading, not guilty on behalf of Mr. Lewis. As to bond in this matter, there's a recommendation from law enforcement for $5,000, 10%. Mr. Nunley, do you have a response to that?
Yeah, I would ask for a personal bond in this matter. And frankly, I don't really see why that bond recommendation is there. He has no priors. According to him, he has absolutely no priors, no warrants, no nothing like that. He said in his entire life, he's had a couple of traffic tickets. It's sounds like to me that he's a good candidate for a personal bond. Now, he is dealing with an issue that I think is a little bit unique, which is going to complicate things for him at least. So the alleged victim in this case is a stepdaughter who allegedly has some problems. So he indicates that he thinks that she may be gone from the house and may not be coming back, but he can't verify that. Him and his wife were taking care of the stepdaughter and her 2 children, which I think is like a 3-year-old and a 17-year-old. He's indicated that he's got a big property with 6 acres and he could stay in a barn if he needed to, but he believes that she's not coming back. And he's retired. He's on a fixed income. He was very eager to jump into the facts and try to litigate the case. Now I told him that he's got to wait for a pre-trial and that there's generally a no contact order that issues with these cases. I told him I'd be happy to explain kind of his situation to you to see if there was a way in which you could craft this order to allow him to be in the home. But besides that portion of it, I don't see a good reason why he shouldn't be given a personal bond in this matter. I mean, he has no prior conviction. He's already trying to adjudicate it. He's eager to get back to court and get this thing underway. So I'd ask the court to consider a personal bond on his behalf.
Is Mr. Lewis, is there anywhere else that, back up, I'm sorry. Is your stepdaughter, has she been living on the property prior to these events?
Yes.
How long has she been there?
Since April 29th.
Is there anywhere else that you can go between now and the next hearing date of the 18th of August?
Your Honor, I can work something out somehow. The problem for me is that my wife has lumbar and cervical stenosis. She has no feeling in her hands anymore, and I actually have to cut her food up for her. I mean, I almost have to be at the house. I can, however, her father, Angela's father, lives in Newport, and she could stay with him for a while. But I can work that out. I can promise you, nothing will happen. I'm
She can't just take my trailer. I said, no, I have already sold my trailer.
Sir, how long have you owned the Clark Street or Clark Road property?
Since 1975.
And it's your understanding and belief that Ms. McCarty's gone from the property?
Yeah, that's what my wife told me yesterday. I haven't talked to her today.
Mr. Lewis, I'm asking these questions because I do have your criminal history in the file. I can see your date of birth, and I see that you have no prior contact with law enforcement. For that reason, in keeping with Mr. Nunley's argument, the court will enter a personal bond, $5,000 personal in this matter. You are to have no contact with the alleged victim in this case, that being Angela McCarty. The court will not bar you from the property in as much as you've given an indication that it is property that you own, that the alleged victim in this case, the alleged victim in this case has been a short-term person at that property. The parties are to return for pretrial on August the 18th, 2021 at 10:45 a.m. That's back with me by Zoom. But Mr. Lewis, no contact with the victim means no contact, no direct contact, no contact with third party, no contact with social media. Understood.
Yes,
Anything
ma'am.
else, Mr. Nunley?
Nothing further, Your Honor.
We're all set with Mr. Lewis. Good luck to you, sir. I'll see you in a couple weeks.
Thank you very much.
Mr. Nunley, you still need to speak to Mr. Gambles, had you already done that?
Already.
You already done that. This is, are these all just money?
Yes.
This is 152527SM 19V000289OI 2481OT. These are all defendant Robert Jeffrey Gamble's. Appearance, please.
Royce Nunley on behalf of defendant. They've already been adjudicated. He's already been arraigned and entered in pleas in all of the cases. For the purposes of today, I mean, if there is a formal reading to waive, then we'd waive it. Yes. Enter a plea and not guilty, but he's indicated to me that he would just like to try to get on a payment plan and try to keep the payment plan. He's had a slew of medical issues. He had a kidney transplant 10 years ago. COVID. He just either extremely recently had a bladder infection that moved over to his kidneys. And being a transplant patient, he has a whole bunch of medication that is imperative that he keeps on top of. Well, since he's been in jail, he hasn't been able to take any of this medication. So I'm pretty desperate to get this taken care of and at least get out of there back to his medication as soon as possible. It is just fines and costs. All of the cases are extremely old. I told him they're not going to go away and that the warrants are just going to keep issuing unless he gets on a payment plan. He's indicated that he is working, that he wants to get on a payment plan and just make his payment so that he doesn't have to deal with this sort of thing.
Sir, would you state your name for me, please?
Pardon?
Would you state your name for me, please?
Robert Jeffrey Gambles.
Mr. Gambles, what Mr. Nunley just indicated is accurate. In these matters, it's just not just money, but these are money owed to the court, a total of $2,258. The warrants have already been canceled. I'm going to make notation in the file that you're being directed to contact the court's collection department. You can either go online and submit an email request for a payment plan. You can call the court for a payment plan, or you can physically come to the building and establish a payment plan. But again, warrants have been canceled. But if you don't make arrangements and establish and keep a payment plan, they're going to issue another warrant, and the same thing is going to happen. Every time a warrant is issued, there's going to be another bench warrant fee added to the file. For the 2015 case, which was a possession of marijuana, there's $548 due. The 2019 case was a failure to yield. There's $334 due. And the 2016 driving while license suspended, there's $638. Again, all the warrants have been canceled. Please contact the court for a payment plan.
Yes, ma'am.
Anything else, Mr. Nunley?
Nothing further. Good.
Anything else from here on behalf of Mr. Gambles?
No, ma'am.
So is that a PR, Your Honor? Just have him contact the court for those payment plans?
Yes, sir. Technically, the warrants have been canceled, so.
Okay. Okay, thank you. Nothing else from here on.
Thank you. Take care. Thank you, Mr. Nunley. I'll see you back with Romulus as soon as you're able.
Okay, should I hang out here or should I call them to get them in the
You can hang out here. Marianne will call Andy to get Romulus on so you can chat with them.
Okay, I'll just mute my mic here.
Warrant canceled. Miss Maddox, are you back with us?
Linda, put your sign up again.
So high tech.
I'm here.
Have the parties had an opportunity to speak in Royal Village versus Maddox?
We have, Your Honor. I believe we have.
Who is that talking? I'm sorry, Mr. Robinson, you say you believe you have a resolution?
Yes, Your Honor.
And what is that, sir?
Your Honor, this is a date and time set for a hearing on a complaint for just cause termination. And I explained to Ms. Maddox the procedure and how we're going to proceed. That the court.
Ms. Maddox?
Yes.
Are you by chance driving with the window down?
No, I'm not.
It's just road noise, but it's keeping me from being able to hear the proceedings this morning. Is it possible for you to stop for a second? so we can hear what the resolution is, or?
Yep.
Thank you. Mr. Robinson.
Yeah, Judge, I've explained to Ms. Maddox that because this is she had a concern about being able to sell her unit. I explained to her that this is a just cause termination, and that pursuant to statute, she does have the right to sell that unit. We have agreed to extend the statutory 10-day move-out date for 21 days to August 24th, 2021. If she does not move by that date, the writ would issue.
I'm sorry, move by August the 21st?
Oh, 24th, I'm sorry.
24.
Correct.
Ms. Maddox,
Yes.
is it your agreement that you will move from this premises by August the 24th, 2021?
Yes.
You understand that if you don't move by that date, that the Royal Village can make application to have you removed from the premises?
Yes, ma'am. I just made sure that
And
I could sell my unit.
Will this be submitted in 7-day or by consent judgment?
Judge, I think I'm going to submit it under the 7-day.
Ms. Maddox, inasmuch as you've indicated on the record that this is your agreement on how the parties will proceed, Mr. Robinson will submit an order to that effect to the court. If you receive it and it is not what the parties agreed to, please contact the court and indicate the same. Otherwise, the court will be waiting for a proposed judgment that indicates that you will move from the premises on or before August 24, 2021.
Okay.
Anything else, Mr. Robinson?
No, Your Honor, not on this matter.
Anything else, Ms. Maddox?
No, ma'am.
Thank you. Everyone have a good day.
Thank you, Judge.
You too.
Mr. Robinson, I'll see you back at 11 o'clock.
Yes, Judge.
Thank you. Oh, nope. Ms. Cadell, shoot. Mr. Robinson.
Hi, yes.
Hi. Have you spoken to your attorney this morning?
I spoke to him through text message, yes.
Okay. The plaintiff's attorney is here. If your attorney gets on, if the parties need an opportunity to speak, otherwise the court will call the case as soon as both attorneys are here. Mr. Ebright.
Okay.
Okay, thank you.
All right, thank you.
Judge, do you see my client up there?
No, not yet.
I don't.
Oh, okay, thanks.
Hey, Royce, are you there?
Yes,
Hey, hi. The PD's here. I'm going to put you in a breakout room.
sounds good. Thank you.
Thank you.
Good morning.
Good morning, Your Honor.
How are you, sir?
I'm well, and you?
I'm good. The attorney is here. Please join in the breakout room.
All right.
Mr. Ebright?
Just want to put him in with Steve if he needs to go.
Oh, okay.
No court officer, nobody comes.
Mr. Ebright, can you hear me? I just sent him a chat, Steve, to see if he needs, do you guys need to go into a breakout room?
Yeah, I think just briefly.
Okay. Steve, can you go back into breakout room 1? Thank you. Mr. Ebright, I'm going to put you in a breakout room with Mr. Robinson.
Sounds good.
Mr. Ebright, are you back intentionally or do you need something else?
No, that wasn't a mess up this time. Are we on the record?
You can't be. I was going to call the case. I was waiting for Mr. Robinson to come back and unmute himself. 211946 LT, Evergreen Town and Country versus Jennifer Cadell. Appearances, please.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Evergreen Town and Country.
Good morning, Your Honor. Andrew Ebright appearing on behalf of Jennifer Cadell, defendant.
Thank you. This matter was scheduled for trial at 11 o'clock. It's 10:57 by the court's clock, but since everyone's here, are the
Judge-
parties ready
Judge,
to proceed this morning?
Yeah, is my client there? Rick Baker, do you see that anywhere?
I do not. Was
Judge,
he
if-
here?
I don't know if he was or if he wasn't. Judge, do you mind just passing on this just for a moment so I can give him a call? I just want him to be on the record for this. So,
Absolutely.
thank you, Judge.
Mary Ann, could I have a few more minutes in that breakout room?
You bet.
Thank you.
Welcome. Romulus, can you go back into breakout room 2, please?
No, I don't. No, I was saying something about.
Lieutenant Jackson, they just need to go back in the breakout room,
Okay.
please.
No problem.
Thank you, sir.
Hey, Mary Ann?
What do you need?
Yes.
Oh, I'm sorry, Judge. I was trying to get in touch with Mary Ann to see if my client, he said he was coming right on, so,
Not yet, Steve.
okay. Thanks. believe we're ready, Judge.
Two 1946 LT Evergreen versus Cadell. I already have your appearances, and I believe your client is now in the main session. If he would activate his video.
Got it, Judge.
Mr. Robinson, you were starting to say that you believe the parties had a resolution.
Yes. Mr. Baker, can you unmute? Can you hear me, Rick? Oh, we can't hear you.
Yo, how's that?
Okay, good. Yeah, Judge, today's the date and time set for summary proceeding on a just cause termination. The court may or may not remember when we were back before you, I think it was about a month ago. We adjourned this to allow the defendants an opportunity to have time to vacate the premises. My understanding, talking to Mr. Baker, my client yesterday, that they have vacated and have tendered the key to Evergreen. My client was a little bit concerned because I guess the spirit of the unwritten agreement he didn't feel was fulfilled. I explained to him that, and that has to do with the condition of the unit, Judge, not with the fact that they vacated. I explained to him that from a practical standpoint, this is just a just cause termination, and that because they left, there's really nothing we can do. So that's where we're at, Judge. And I just wanted the court to maybe explain to Mr. Baker that since they vacated and we're not asking for a money judgment, there's no reason to get a judgment on this because they've already tendered the keys. Does that make sense, Judge?
Inasmuch as this is a case regarding possession and your indication is that Mr. Baker has retaken possession of the premises,
That's correct, Judge.
implied in your statement is that this matter is being dismissed?
Yeah, Judge, I think that's the way we needed to go. But again, Mr. Baker, I think he wanted an opportunity just to address the court because he wanted to pursue a judgment on this, but I don't think the judge could, after taking testimony, would hear that they vacated, that the court could enter a judgment on this if the court understands my position on it, so.
I do understand, and Mr. Baker, that would be the court's conversation as well. This matter is a termination of tenancy with a notice to quit for the mobile home park from March the 22nd, 2021. Inasmuch as the only thing plaintiff sought was possession of the premises, and you're now indicating that you have possession, there is no other issue remaining as relates to the termination. If there's some other monies or something else that is due to you from Ms. Cadell, that's another matter for another day in another case. Does that make sense to you, sir?
Yeah, I understand that. I just don't want them to do this to another person is what it was. They moved out real bad, and then they put in they asked for the time, and then they didn't meet the time, they went beyond, so, but they are gone now, so.
Okay. So Mr. Robinson, will that dismissal be coming from your office today, tomorrow?
Judge, I'm gonna try to get to my office today, but I've got 2 more hearings. So if not today, it'll be tomorrow. I'll bring it in personally, Judge.
Thank you. I'm sure Sandy will be happy to receive it from you. Mr. Ebright, we've had this conversation without you. Is there anything you wanted to add in this matter?
No, Your Honor, other than we're not making any admissions regarding the state that it was left in. That's not an issue that we're touching on. Just want to be clear about that.
Another issue for another day. How's that?
That's right, Judge.
I'll wait for the dismissal, Mr. Robinson. Ms. Cadell, good wishes to you. Mr. Ebright, have a wonderful day.
Thank you, Your Honor.
Thank you.
Thank you. Have a good day, Mr. Baker.
Thank you.
Mr. Nunley, was that sufficient time with Mr. Banks?
Yes, Your Honor, we're ready to proceed.
This is 210282FY, State of Michigan versus Terrence Deshawn Levitt Banks. This matter is scheduled for arraignment this morning. Appearances, please.
Royce Nunley appearing on behalf of the defendant. We'd waive a formal reading and ask the court to enter a plea of not guilty on his behalf.
State your name for me, please, sir.
Terrence Deshawn Levitt Banks.
Thank you, Mr. Banks. Are you able to hear Mr. Nunley this morning?
Yes, I can hear you both now.
Thank you. Waive formal reading, plea of not guilty on behalf of Mr. Banks. Sir, you have a right to have a preliminary examination in this matter. You also have a right to have an attorney present. Mr. Nunley is here with you this morning for purposes of arraignment. There is a petition for a court-appointed attorney attached to the front of your file so that you have counsel going forward. The court has signed that order. You will be assigned counsel from here until this matter is resolved. You have a right to be considered for pretrial release. There is a law enforcement bond recommendation form from the Romulus Police Department where they are requesting a cash bond of $250,000 with a no contact with the alleged victim in this case. Mr. Nunley, what say you in response to this recommendation?
Well, there's quite a few different working parts in this case, apparently. So he has just finished a trial in Ohio that he alleges that are coming from the same alleged incidents here. He was found not guilty at that trial. He's indicated that there were already some sort of similar charges brought in Detroit, I guess in 36th district maybe, for conduct that is alleged in this case. Now, I don't have any of his file in front of me. This is what he's relayed to me. He said that those charges were not found over. Then they took him to Ohio, where he had a bench trial where he was found not guilty. They subsequently brought him here. Now, the alleged incident date was May of 2020. Now, these charges were just brought, so it's been a year that this has passed before they charged this. He's been incarcerated the entire time. Since May 2020. So he's over a year, he's been sitting in jail, right? Now, we understand the allegations, are serious. According to Mr. Banks, he's been fighting these for a year, and there's still not a conviction on his record. Now, the police report is what the police report is, but I did notice, just kind of breezing through it, that they did do some DNA testing, and there's a fraction 1 and a fraction 2. So the fraction 1, they did a vaginal all cervical swab, which excluded Mr. Banks as a contributor. So the fact that he's been in there for a year without them bringing these charges, I think has prejudiced him, obviously. We would ask that the court consider some sort of bond that'll get him out from there so that, he can obviously continue to fight these things. And like I said, I don't have his record in front of me, but from what, he's told me, this has been something that he's been dealing with since May of 2020.
Mr. Nunley, all that the court is able to go on is the recommendation from law enforcement. I don't see any indication that what these other matters were that you're referring to, either the Ohio case, whatever happened in 36, or anything else. The court just looks at the seriousness of the allegations. And the court is going to adopt the recommendation of law enforcement, $250,000. Cash 10%, no contact with the alleged victim in this case, that being Nevaeh Green. If you are able to determine that these charges were previously brought and adjudicated, or some fraction of the cases, That's a matter that can be brought up at the PCC, which will be scheduled for August 11, 2021 at 8:30 a.m. Back by Zoom, back with me. Anything else, Mr. Nunley?
Nothing further, Your Honor.
Anything else, Lieutenant Jackson?
No, Your Honor, thank you.
Thank you. We're all set. Have a good day, Mr. Nunley.
Thank you, Judge.
Mary Ann, I think that's it for us. It's 11:12 and I haven't received anything else from Andy.
What's she say about?
Okay.
Thank you, ma'am.